evidence upon which the court can rely on. The evidential burden shifts to the first defendant, who has failed to show that the claimant is not entitled to the sum of 578,800 naira being claimed by the claimant. The claimant's counsel reproduced the answers elicited from the claimant and DW1 during their respective cross-examinations and argued that the best proof of payment into a bank account is either by oral evidence of the person who personally made the payment or by production of the bank teller or acknowledgement on the face of it by the bank showing that the payment was received. Counsel referred to Ishola versus Societe Generale Bank, Nigeria Limited. Citation is also provided. Now, with respect to Exhibit DW1A, it was submitted that the document has no maker and is not dated, that it has no relevance to the case of the claimant before the court, that an unsigned and undated document is worthless and has no probative value. The court was urged to expunge Exhibit DW1A from the records. Counsel referred to Maku versus Almakura and Global Soap and Detergents Limited versus NAFDAC. Citations are both provided. The Exhibit DW1G was merely dumped on the court and should also be discountenanced, that since the first defendant did not deny that the claimant worked for the months claimed in this suit, the claimant is entitled to his salaries for the work carried out by him. Counsel referred to Okun versus Omatech Ventures Limited. Citation is given. With respect to the contention of the first defendant that there was an oral agreement with the claimant to be retained in the employment of the first defendant without pay, it was submitted that the onus of establishing such agreement is on the first defendant, who alleges the existence of same. And the first defendant has failed to prove the elements of a binding agreement, such as offer, acceptance, consideration, and capacity to enter into a contract, as well as the intention of the parties. Counsel referred to Taura versus Chuku, Corn Oil PLC versus Woki, and Odutola versus Pepper Sack Nigeria Limited. Citations are all provided. On the first defendant's contention that the claimant's contract was not terminated, but he was rather placed on the stand-down, the learned counsel to the claimant drew the court's attention to different definitions of the word stand-down and argued that by the title of Exhibit CW1B as redundancy, it leaves no one in doubt that the first defendant had brought the contract to an end. The court was urged to give Exhibit CW1B a holistic interpretation. Counsel referred to Modakat Nigeria Limited and another versus Akman. Citation is given that the clear intention of the first defendant is to bring the claimant's contract to an end via Exhibit CW1B, referring to the case of Olafimihan versus Nova Late Tech Limited. Citation is also provided that the first defendant failed to comply with Section 20 of the Labor Act before declaring the claimant redundant. It was further argued that since the first defendant's reason for terminating the claimant's employment is business downturn and inability to pay salaries, the first defendant has the duty to prove the reason or reasons for the termination, and there is no evidence before the court to show the first defendant's loss of contracts. On the claim for general damages, it was posited that by Order 55, Rules 1 and 5 of the Rules of this Court 2017, the court has the discretion to award cost and to ensure that the successful party is indemnified for the expenses he incurred in prosecuting the suit. Counsel referred to NNPC versus Cliffco. Citation is given. The court was finally urged to enter judgment in favor of the claimant. Now, cost decision. After considering the pleadings, evidence, and submissions of both learned counsel to the parties, I am of the view that the suit can be determined on the basis of the single issue identified and argued by both parties, which is whether on the basis of the claims and totality of evidence in support, the claimant has been able to prove his case to entitle him to judgment against the defendants. before I consider the sole issue identified for determination in this suit. It is apposite to first resolve the objection of the claimant's counsel to the admissibility of exhibits DW1A and DW1G. According to the claimant's counsel, while exhibit DW1A is unsigned and undated, exhibit DW1G was merely dumped on the court. The court was asked to discountenance the two exhibits and expunge them from the record. I have gone through the document. The documents been objected to and saying that exhibit DW1A is a document titled, quote, provision of civil security guard service in NAOC facilities/managers residences in Port Harcourt district. The document neither bears the name of the first defender, name of any employee of the first defender, and it is neither signed nor dated. The source or origin of the document is obviously in doubt. And since the document is neither signed nor dated, this court cannot place reliance on said. Exhibit DW1A is without any evidential value in law, and same is hereby discountenanced and expunged from the record of the court. I so find and hold. See Ambassador Johanna Yip1 Margift against Labour Party and others, as well as the case of Celtrix Limited versus Edotive Limited and others. Citation is provided where the Court of Appeal for Kenneth Ikechukwu Amadi, JCA, held as follows at pages 24 to 25, paragraph G to A of the report, and I quote, apart from the above statutory provision, the position of case law is that an unsigned and undated document is a worthless piece of paper and has no evidential value in law. See the cases of Amizu versus Nzeribe and Talibawa versus Habiba. End of quote. With respect to the argument that exhibit DW1G was merely dumped on the court, I have seen that the document is a copy of the redundancy letter dated and received by the claimant on the 31st of October 2018. Since the document is relevant to the instant proceeding, I hold that the document was properly admitted and shall be countenanced in this judgment. The objection of the claimant's counsel can only go to the issue of the weight to be attached to the document. Now, with respect to the loan issue, I have seen that the claims before the court have nothing to do with the wrongfulness of the termination of the claimant's employment or declaration of redundancy. I have therefore not seen any relevance in the contentions of the parties as to whether the claimant was relieved of his appointment or merely placed on the stand-down to be reabsorbed as argued by the first defendant. The claimant is simply asking for the payment of his arrears of salaries, payment in lieu of notice, and remittance of his pension contributions to his PFA, that is the second defendant. The claims are clearly in the nature of special damages, which the law expects the claimant, who has the onus of proof, to plead them specially and also prove the relief strictly. See sections 131, 132, 133, and 134 of the Evidence Act. In the case of Adakawa and Sons Limited and another versus Standard Construction Limited, citation is provided. The Court of Appeal for Abundaga JCA held as follows with respect to the nature of evidence required in proof of special damages. And I quote, this claim is in the character of special damages. It is settled law that special damages must be strictly proved. Strict proof that here means no more than adducing credible evidence in support of the claim. It does not mean an unusual proof beyond reasonable doubt. Strict proof in the context of special damages means no more than proof as will readily lend itself to quantification or assessment, where a plaintiff pleads special damages with particularity and give evidence of the special damages and the defendant does not challenge or contradict the evidence given. The plaintiff has discharged the onus of proof, and unless the evidence given is of such quality that no reasonable tribunal can accept it, the evidence has to be accepted. See the case of SPDC versus Okonido. End of quote. I have seen that apart from the claimant's pleadings and evidence in chief, including the exhibits tendered by him, he informed the court during his cross-examination on the 9th of March 2022 and 6th of June 2022 that he was not employed as a guard in the first defendant, and affirmed that from Exhibit CW1G, his salary for the month of June 2017 was paid by the first defendant. He also affirmed that nowhere is 13th month mentioned in his letter of employment, Exhibit CW1A, but that 13th month is mentioned in Exhibit CW1C. He insisted that the payment of 18th of February 2016 in Exhibit CW1G is his 13th month and no salary for January 2016. The claimant further informed the court that even though Exhibit CW1B did not indicate termination of employment, the intention is to terminate the appointment. He affirmed that a check of 50,000 naira was given to him along with Exhibit CW1B which he cashed 2 weeks after the issuance of Exhibit CW1B to him. He affirmed that he requested for a loan of 40,000 naira from the first defendant since he was not paid salary for several months, that he was not a party to the agreement between the first defendant and Ajib Oil Company, that from Exhibit CW1G, the sum of 87,750 naira paid on 18th of February 2016 and 81,000 naira paid on 6th of March 2016 were both for 13th month salary, because while the payment of February 2016 was for 2016 13th month, the payment of March 2016 was for 2015 13th month. The claimant further affirmed that even though pension contribution is not deducted from 13th month salary, but from Exhibit CW1K in January 2016, a total sum of 5,507 naira 54 kobo was paid into his pension account. And also in February 2016, the sum of 5,500 naira was paid into his pension account, Exhibit CW1K. That while the payment for January 2016 was made on the 29th of March 2016, the payment for February 2016 was made on the 14th of April 2016. And for the month of December 2017, the sum of 5,500 naira was paid into Exhibit CW1K. During his re-examination, the witness stated that apart from MSc in economics, which he used in applying for the job, he also has HSE professional certificate from the Institute of Safety Professionals of Nigeria as a certified HSE person. I have also seen the pleadings and evidence of the first defendant, and some of the high points of the answers elicited from DW1 during his cross-examination are that the claimant was employed by the first defendant by letter dated 19th of August 2015. He confirmed Exhibit CW1H as the letter of employment. That while by Exhibit CW1H, the appointment could be terminated by 1 month notice or 1 month salary in lieu, the first defendant did not terminate the claimant's appointment. He refuted the insinuation that the claimant is being owed salary for the months of January 2016, February 2016, December 2017, July 2018, August 2018, September 2018, and October 2018, but affirmed that the first defendant owes the claimant salaries for the months of July 2018, August 2018, September 2018, and October 2018. Excuse me. He affirmed that even though Exhibit DW1G was served on the claimant on the 31st of October 2018, it was for him to stand down and not to stop work. He stated the total amount owed the claimant for the 4 months to be the sum of 339,800 naira, and the claimant's monthly gross pay as at 31st of October 2018, as reflected in the Exhibit DW1G, is 90,000 naira. He affirmed the opening of a contributory pension account for the claimant with the second defendant and that as at 31st of October 2018, no contribution was made for the 4 months the claimant is owed. He also affirmed Exhibit CW1K to be the claimant's pension statement of account with the second defendant. He affirmed that the first defendant has not made any contribution to the pension account for the months of July, August, September, and October 2018. Now, with respect to Relief A, for an order directing the payment to the claimant, the sum of 578,800 naira as unpaid salary arrears for the months of January 2016, February 2016, December 2017, July 2017, and August 2018, September 2018, and October 2018. I have seen that the first defendant has admitted owing the claimant salary for 4 months for the months of July, August, September, and October 2018, totaling the sum of 339,800 naira. Since in law, what is admitted needs no further proof, I hold that the first defendant, having admitted owing the claimant arrears of salaries for the months of July, August, September, and October 2018, amounting to the sum of 339,800 naira, the claimant is entitled to the said amount. This was also admitted by the first defendant in paragraph 1 of Exhibit CW1B and DW1G. The claimant also stated in his solicitor's letters, Exhibit CW1C, DW1D, and DW1F, that he is owed salaries for only the months of July, August, September, and October 2018. See the case of Garkuwa Pina versus Jagaba Meangwa. Citation is provided. Now, with respect to the alleged salary arrears for January 2016, February 2016, and December 2017, I have seen that apart from exhibits DW1B, DW1C, DW1K, and DW1M, which are payment schedules for the staff of the first defendant, including the claimant, for the months of January, February, March, and April 2016. From exhibit DW1G, the claimant received payment from the first defendant on the 18th of February 2016, and also 4th of March 2016, even though the narrations for these payments is 13th month / salary. I hold a view that they are his salaries for the months of January and February 2016, respectively. They cannot be for 13th month because 13th month is not paid more than once in a year, particularly in the absence of any agreement to that effect. The claimant has received his salaries for the months of January and February 2016. That of the month of December 2017 was paid to the claimant on the 3rd of January 2018. The claims for salary arrears for the months of January 2016, February 2016, and December 2017 therefore fail and are hereby discountenanced. With respect to Relief B, for an order directing the first defendant to pay the claimant the sum of 90,000 naira as 1 month salary in lieu of notice, I have seen that by Exhibit CW1A, which is the same as Exhibit DW1H, either party may terminate the appointment by giving 1 more notice or 1 more salary in lieu of notice. The first defendant's contention is that the claimant was not given notice or payment of salary in lieu of notice because the employment was not terminated. He was merely placed on a stand down to be reabsorbed when the economic condition of the first defendant improved. While I have seen that by Exhibit DW1G and CW1B, the claimant was merely placed on the stand down due to the economic challenge faced by the first defendant. I do not, however, think that to place someone on a stand down or standby without salary from 31st of October 2018 to date, a period of over 5 years, is reasonable in the circumstance. This is a clear instance of unfair labor practice, which this honorable court cannot tolerate in the world of work. Having not recalled the claimant, even while the suit is pending in court, I hold that the claimant is entitled to the relief, which is hereby granted. With respect to relief C and D, for the remittance to the claimant's pension account, the deducted pension for the months of July, August, September, and October 2018, totaling the sum of 11,200 naira at 2,800 naira per month. I hold that since the first defendant admitted owing the claimant salaries for the months, the claimant is entitled to pension for the said months. It is also obvious from SDBCW1K that pension remittances were not made into the claimant's pension account domiciled with Stanbic IBTC pension manager for the said months of July, August, September, and October 2018. Relief C and D are meritorious and are accordingly granted. As per Relief C, as per Relief E for an order directing the second defendant to pay the claimant the sum of 323,080 naira 9 kobo as his total pension contributions. I have seen in SDBCW1K that the value of the claimant's pension was a sum of 301,080 naira and 9 kobo as at November 2020. I therefore find merit in this relief, and same is hereby granted. The second defendant did not defend this suit, thereby leaving the court with no option than to act on the evidence of the claimant, which I have found to be plausible. Relief E is therefore granted. With respect to Relief F, for general damages against the first defendant only, I have seen that the first defendant withheld the claimant's salaries for a period of over 5 years. The claimant is certainly entitled to general damages, which I assess at the sum of 250,000 naira. I therefore award the sum of 250,000 naira to the claimant against the first defendant as general damages. In the final result, the claimant's case succeeds in part, and the court makes the following orders. 1. The first defendant is hereby ordered to pay the claimant the sum of 339,800 naira as his arrears of salaries for the months of July, August, September, and October 2018. 2. The first defendant is hereby ordered to pay the claimant the sum of 90,000 naira as 1 month's salary in lieu of notice. 3. The first defendant is hereby ordered to remit to the claimant's contributory pension account the employer's portion for the months of July, August, September, and October 2018, totaling the sum of 11,200 naira at 2,800 naira per month, and also the employee's portion for the months of July, August, September, and October 2018, totaling the sum of 11,200 naira at 2,800 naira per month. 4. The second defendant is hereby ordered to pay the claimant the sum of 323,080 naira 9 kobo as his total pension contributions. 5. The first defendant is hereby ordered to pay the claimant the sum of 250,000 naira only as general damages. The terms of this judgment shall be complied with within 30 days from today, failing which it shall attract interest at 10% per annum until it is completely liquidated. Judgment is entered accordingly, and I make no order as to cost.
As the court pleases, we are most grateful, my lord.
Thank you. So you have copies of the judgment anytime from Monday next week.
As the court pleases.
All right. Thank you.